co-hosts. Thank you both for joining us today. We're going to be discussing our key differentials and adding tangible value for understanding intellectual property. And I'd like to welcome the following industry experts to talk on this subject today. I have Dan Ho, partner at Resolute Legal. He specializes in technology law, having litigated numerous patent and trademark cases. He has extensive expertise in patent prosecution, intellectual property counseling, technology licensing, and has held key roles in global companies such as Tata Communication and Accenture, contributing to over a dozen mergers and acquisitions. Thank you for joining us, Dan.
Thank you, Autumn,
And
for inviting me.
perfect. We do have Michael Capel, founder of the Lakeland Advisory Group, which focuses on complex business valuations for intellectual property, among other things. In addition, Michael has testified on IP matters in federal court, and over his career, Michael has performed hundreds of valuations focused on IP matters. Thank you for joining us.
Autumn, thank you for inviting me.
Great. First question, Michael, can you tell me how a consulting firm is able to assist a private equity firm in determining whether to or how much money to fund a company?
As it pertains to intellectual property, IP, software, technology are playing a key role in the assets of the company. And whether it be private equity or anyone acquiring or selling a company really has to understand the true value of that intellectual property, especially as it pertains to IP. By this very definition, patents are very unique and they require a totally different skill set than the normal business valuator would have with those. Also, in addition to that, generally, intellectual property such as patents may not be at a point. There may be pre-revenue. Therefore, to attempt to value them based upon their income flow is not applicable. So we have to come up with numerous other characteristics to derive a true value for it. And as it pertains to startups and companies going in distress, challenging enough, those are probably the most important assets are the intellectual properties.
That's good to know. Now, to piggyback off that, Dan, what are some of the patent trademark due diligence that can be performed prior to investing in a company or the intellectual property?
Yeah, that's a great question. So as far as for patents, I'll address that first. There's various things that we can do by looking at the records at the U.S. Patent and Trademark Office, and those are probably the things that is the easiest thing to do and then most necessary thing to do. And so the first thing we can do is look at what the ownership of the patent is. A lot of people think that, okay, just because you're selling the patent, you must own the patent. But that might not be true. There could be joint inventors, joint ownership of the patents that we want to investigate to make sure that whoever said they own the patent truly own 100% of the patent, and then there's not a lien on the patent. So we want to make sure that's true. And then there's other things that we can look at with the patent office. So we can look at basically to make sure the maintenance fee is fully paid up. There's periodic maintenance fees that needs to be paid. And so if we're interested in terms of investigating a patent that's owned by the owner, we want to make sure that they actually pay the maintenance fee and there's not a a problem in terms of that the maintenance fee is not paid or some other effects that we want to know about prior to recommending that somebody would either buy or invest in the patent. And also we want to look at basically, some of the other things that's available through the patent office, such as, the life of the patent. A lot of times it's supposed to be 20 years from the date of filing, but sometimes the patent office might give additional times because it was a difficult prosecution, it went through appeals and things like that. They might add on to the date. And so those are the things that we want to be aware of about the patent in terms of when is it that this patent is actually going to expire. And so those are the things that we can investigate with the patent office. And also based on the prosecution history of the patent, we can learn a lot about what the patent's about. For those of you who does not practice a lot in the patent field, prosecution history is basically the arguments that's going back and forth between the patent owner or actually the applicant at the time with the patent office. And so these would include things like amendments that might be made and also arguments that might be made on both sides, right? So the patent owner might be making certain arguments and also the examiner making certain arguments. And through that, we can see what is it that this patent is really focused on? What is the what is the aspects of the patent that we want to look at. And so those are the things that we can get from reviewing the records at the U.S. Patent Office. In addition to that, there's other due diligence that we can
Mhm.
do that's going to be very helpful to understand, the importance of the patent, and then what are the possible problems with the patent.
Mhm.
One of them is looking at the litigation history of the patent, and we can do that through records of the federal courts. We can look at whether the patents have been litigated, and if it's successfully been litigated, then that is a good hint that okay, that it's going to survive another litigation. So we can look through things like that, and also we can look at basically additional prior art searches. And again, prior art search, what that means is that when it's going through the patent office, it was originally reviewed by the examiner at the U.S. Patent and Trademark Office. And then those records of what the patents that were reviewed are actually what we call prior art. So prior art are patents or publications that was available prior to the filing of the patent. And so those a lot of times would be cited by the examiner, or could be cited by the applicant. But then, as we know, there are millions and millions of publications out there. And so the examiner during the review, he might only have a certain small amount of what's available prior art, just because he doesn't have, you know, 10 billion hours to do the review or 10 billion hours to do a search. And so it's very possible there might be prior art out there that was not examined by the examiner. And so we can actually do an additional prior art search to see if there might be prior art that might come up, that the examiner did not cite to or was not aware of. And then those are things that we want to be aware of, before we make an assessment about the valuation of the patent, because, if there's another patent or application or some other publication that's spot on, and then now that could be something that could be brought up if it was but if it was litigated, and the defendant can bring that up. And so we can actually do additional prior art search to give some kind of assurance that the examiner looked at what they're supposed, that what they had available, and then what can be available out there. And the other thing that we can do, in addition to basically looking at saying that, okay, there's a prior art that could be problematic, is when we look at prior art, we can also determine who are some of the major competitors in that area. So we can look at the patents that the patent that we're looking at is citing to, and also what patents are cited to this particular patent. And then we can look at who are the owners of these patents, and we can kind of give a overall view in terms of, who are some of the competitors out there. If that was, someone that is really big, let's say IBM or someone like that. Now we know, oh, okay, this space isn't something in IBM space or something like that. So we can make some assessments on that. And so obviously, like I said, there's various things that we can look at in terms of, what's available at the U.S. Patent and Trademark Office, but also other investigations we can do as far as due diligence on these patents that a company might be looking to invest in or purchasing. We can give them some assurance that what they're looking at is a good patent.
Well, Autumn, it's those points that Dan just outlined that make
Mhm.
our combined forces add significant value for our clients. Lakelet Advisory Group, we've done hundreds of business valuations and crunched the numbers, but we also look at the market, the potential market for things. But with Dan on board helping us take a look at that, we look at the total environment from the legal perspective, which is paramount for patent, also to the business side in the sector. And by our combined team, that's really a
Right.
major differentiator of what we do versus our competitors.
That's a great way to say that you guys make a wonderful team. You're protecting both, the client that's interested in investing, as well as doing a fair valuation for the company or, intellectual IP that they're looking at. So I think it's great that you guys are able to utilize your resources together and bring a great and powerful team to that company that's looking to do, these investments in these intellectual IP properties. So,
And the other thing, Autumn, I don't know if Dan will concur, is that the patents are getting much more complicated now. It's not like the patents of 30, 40 years ago, or even 20 years ago. We're dealing with software, artificial intelligence, biogenetics. I mean, the degree of patents and the sophistication is geometrically more challenging than it was in the previous generation.
Yeah, definitely. Michael, I think you hit it nail on the head in terms of the patents today. When I start being a patent, start doing patent prosecution 25, 30 years ago. And the type of patents we're looking at now are so different. And then how the courts and the patent office are treating the patents are so different than it was 20, 30 years ago. And I think one of the things you brought up is that now we're looking at a lot of the patents out there are not just mechanical or chemical patents, which are the ones when I started off doing prosecution on, but a lot of it, like you mentioned about like software, artificial intelligence, machine learning and all that stuff like that. It is very difficult to understand and also to assess in terms of its value without someone who actually are familiar with that or actually familiar with that field too, because it's getting more and more crowded in that area. But also I mentioned before that the treatment by the patent office and the courts are so different now than it was 25, 30 years ago. About 10 years ago, there was what's called 101 rejections. And what that is 101 rejection is the Supreme Court kind of mentioned about saying that, okay, like it's not just a patent has to be overcoming the prior art, but now it has to be a patentable subject matter. And then what they do is, what that's called 101 is that they look at saying that, oh, is this something that's a patentable subject matter? And if it's not, then we don't even allow the patent, even though it might overcome what's new and obvious. And then that's something that's kind of new, like I mentioned about, by the Supreme Court kind of came down with that decision. Then now we have to account for that before that we haven't had to. And that's an additional due diligence that's required by our part when we're looking at the valuation is that, especially things that's software related or machine language related and all that stuff like that. The defendant is not going to just cite prior art and saying that, hey, like these, it's not new and obvious. They're gonna say it's not a patentable subject matter, and that's something that we have to look at now that we haven't had to look at, 25, 30 years ago.
No, you're absolutely right, Dan. And the challenge is been a CPA for several decades and accredited business valuator. But I think in this realm, probably my most important experience is I was a senior IT executive for a Fortune 500 company. So I know from what I speak when we work together about what the technology is, the cost of technology, the risk of technology, the entire gamut. And with your expertise, we also now uncover the legal realm as it pertains to these intellectual properties.
Yeah, I think it's a great partnership that we have together, and then the fact that we can incorporate the fact that I can contribute in terms of some of the knowledge we have, an understanding of the IP. When we're talking about valuation, and then when we're talking about whether it's even worth pursuing, funding or investing in these type of IP. I mean, this is something that really should be brought up in the forefront before negotiation starts. Because it would greatly
Yes.
either affect the negotiation or even stop the negotiation. In worst case scenario.
I was going to ask, what is the best advice each of you can give to a company who's looking to embark on this journey? What is the best advice that you could give them starting this process?
I would say start the process soon and get someone who's willing to tell you the good, the bad, and the ugly.
I absolutely agree, Michael. I mean, it's like even now, I mean, I don't want to, name any names and stuff like that, but even recently, I've been involved in some funders I think they were going down the path of looking to funding, and then they were looking more from a business standpoint of saying, which is the thing that they need to do, obviously, but then they're kind of going down the road, asking for information, looking at the valuation and things like that, without even doing the due diligence to start with.
Mhm.
And then I was kind of surprised in terms of them saying that, okay, like we'll eventually get to that at some point. But then, you're just kind of putting the cart in front of the horse, right? So, it's kind of like you did all this background work, and then all at the end, you found out, oh, wait a minute, we got some problems here. Now you have to either restart the negotiation, or or just kind of like eat, what you already have, and then that's not the best way of doing it.
So, Dan, thank you so much for talking about patents. Can you tell me if this exists for any other type of intellectual properties?
Yeah, thanks. Yeah, definitely. The one that comes to mind are trademark and software. So I'll address the trademark first. So
Mhm.
for trademark, we can do the same kind of process that we did for patents. That includes, looking up the ownership, that whether the maintenance fee is paid, and then look at the history of the prosecution of the trademark.
Mhm.
Matter of fact, there's also other things that we would do similar to patents, in which we want to look at whether there's other trademarks out there that maybe the trademark examiner was not aware of. In
Mhm.
fact, it reminds me of a litigation that I had when I just started, in which a competitor sued our client for a particular trademark that they had. And these are two very well-known companies in the
Mhm.
same space. And as it turned out, our client actually used that trademark before they did, and they weren't aware of it. And so, in a
Oh.
way, they assert the litigation against our client, but then because they didn't do their homework, we actually came back and said, you infringe our trademark, because the trademark is based on use. And so now we were the hunted, and now we're the hunter.
Mhm.
So it is very important for trademarks uh, due diligence to make sure that that you are the one that had the original use, not somebody else, especially your competitors. And
Mhm.
so we can do a very similar type of review for trademark as we do for patents, and in some cases, most people don't think of that, but it's actually just as important, if not more.
Mhm.
And
No,
as far as
I have to agree with you, Dan, especially with some merger and acquisitions, mid-sized companies being bought or sold, and they're turning over all the assets and over all the assets. Are the trademarks and are the patents and are the copyrights really true assets that can be enforceable and we can value and move forward with that?
Right, absolutely. And it's not just enforceable, but you could be infringing somebody else's trademark
That's right.
unknowingly too, if a due diligence is not performed.
And you're inheriting someone else's hornet's nest.
Right, right,
You really
exactly.
are. You get someone else's problem because you didn't do the due diligence properly.
Right, right. And that actually leads into the other type of due diligence that I think is really important to do. That is software. And then there's a couple of things that we need to do in terms of due diligence for software that to me is very important. First one is to understand who actually owns that software. A lot of times nowadays, it's not just your employees who's running the codes. You have independent contractors out there. You have other people who's helping out in terms of you hired to do this kind of work. So you want to make sure that they assign the rights to the owner that we assume is the owner at this point. And so we want to review the independent contractor agreements to make sure that they indeed assigned those rights to the company that we think that owns it. And then that's something that again we want to do early on
Mhm.
before we get into negotiating in terms of a price or whether to purchase it and how it's being used, is make sure they actually own it. And that's something that we can help in terms of doing by making sure that everyone that was involved in terms of creating that software actually assigned the rights to who we think is the owner for that particular
Yeah,
software.
you're right, Dan, because one of the many things, the code now is, I can't envision a situation from beginning to end is developed internally. So everyone custom pastes from other modules.
Right.
If you have a payment module, who do you borrow from? You have artificial intelligence to put in code. Well, how do you know that code is original code, open source code? There's a whole another degree of complexity when you take a look at software in today's market.
Yeah, absolutely, Michael. And I think that was the other point that I want to get to. And I think you kind of beat me to the punch, is that, we want to look at not just who owns the software in terms of assignment of the software, but we also want to know what's embedded in the software. And so, like you said, like nowadays, it's not like, when I was in school, whatever I had to say, like 40 some years ago, when I was using punch cards, right? And then
Yeah.
we're writing software for the first time. Nowadays, a lot of the software that's out there is a collection or derivative work. I guess that's what, for what we would use the term derivative work of other software. And so what it is that they would incorporate other type of software. And then a lot of them are probably licensed software. And then so we had to understand the type of license that the software is, the license is covered by the software that's covered by those licenses rather. And so there's, basically some of them are commercial software. If they're commercial software, we want to make sure that we comply to the agreement. And if it's royalty, if they require some kind of royalty, we got to make sure that we account for that royalty when we want to license that software, because now we have to pay to whoever it is that software we're using. And then also, I think the other main thing that you bring up is that nowadays, open source software is prevalent everywhere, and I think everyone I talk to, they're proponents of saying that, oh, open source software is great. And most people don't realize is that open source software is still a licensed software. It's just that you don't pay for the license, but then there's still terms within those open source software. And then this is where it gets to be problematic for us to use a software and one use it for commercial purposes, is that there's really at least two types of open source software. There's basically, I would say, copyleft software. And those are the more problematic type of software. And there's ones that's not as problematic, and those are the permissive software. So permissive software would be like something like Apache, MIT, Berkeley. Those are the ones that basically say, hey, you can go ahead and use this software. There's no fees associated with it. Not the only thing, but the main thing is that you can't sue us if there's a problem, and so those are the permissive software. The more problematic are what's called copyleft software, and those are like the GPL software. And then what that is that you have to, whatever the terms of the license under the software, if you were to make a derivative work out of those software, you had to use that same license. So GPL, what it is, what the problem with that is that if you to embed a GPL type of software, and I guess it's other type, but GPL is just the most well-known license, that means that you cannot get a royalty for your software now.
Wow.
So let's say, we used, a couple hundred lines out of a GPL open source software in our software, but then this is where we want to get a royalty for it. We want to license this software for royalty. We can't do that anymore because, we embedded these GPL software. And so there's, things that we can do by reviewing what kind of licensed software are embedded in the source code. And so there's companies that we work with, in which they would whoever were the software owner is, they can send the source code to them, and then we get something back in terms of saying, hey, these are all the embedded software, and then we can identify saying these are the potential problematic embedded software that's in there. It could be copyleft software, or it could be a software that requires royalty. And so these are things that we need to know beforehand.
But the challenge is, Dan, as we talked about with patents, but specifically with software, they're only going to come after you, a competitor, after you're successful. No,
Right.
no one's going to know what's written in the back room. It's only when you're marketing that and have a great software and it's getting everyone's attention that someone's going to tap you on the back and say, "Oh, did you know, by the way, that's ours?"
Right. Exactly. That, or, like either that it's ours, or basically say, hey, like we're not going to pay any royalty for this stuff. We've been
That's right.
using, we want that royalty back because you weren't supposed to charge the royalty in the first place, because it's a, copyleft, you embedded copyleft software. And so the terms of your agreement is invalid. You can't charge us for it. And then all of a sudden now you got the software that you might have invested a lot of money, not just in terms of getting the software, but then in terms of marketing the software, all of a sudden it's, poof, it's gone.
And there's a lot of ways today for the average software house or company to check their software. You can run it through some AI modules and it'll let you know if it's
Right,
someone else's
exactly.
software. Oh yeah, I saw this source code in ABC's API, or I saw this out there. And then you're going to have some problems.
Right, exactly. And then by knowing this in advance, I mean, there's certain things that we can do to fix it, or
Yeah.
to account for it, right? And so if we were to know that there's a software in there that requires a royalty, or has some terms in there, then we got to make sure that those are complied to. If it, let's say it was embedded software that requires a royalty of a certain amount of money, we build that into that whatever we want to charge, and then make sure that we pay the necessary royalty. If it's open source software, especially if it was some kind of a copy left software, I mean, there's certain steps that we can do.
Yeah.
First thing we can do is saying that it doesn't matter. I've worked in terms of some mergers and acquisition, in which there were some copy left software, and then now the point is, it's like, okay, do we care? And sometimes we might not care, but that's the due diligence we need to do,
But
because
at least with this environment, the process that we go through, Dan, we can control or mitigate the risk and know the risk in advance rather than be
right,
surprised
exactly,
down the road. And that's the secret to the whole thing.
right,
Do your due diligence right.
Well,
right,
that being
exactly.
said, Michael, with this due diligence, how does that affect the value of the company or the IP, the software, the patent, the trademark? How does that affect that value?
It affects it significantly, Autumn, because if it's not original and if it's not
Mhm.
marketable and it has all these associated risk of whether or not it's has the copyright or a valid copyright, it
Mhm.
would do it significant. And it's very hard now in the software world because so much of the software is developed worldwide. And you really got
Yeah.
to take a
Right,
step back and understand what you're getting into. And software, in so many cases, is such an important asset in the company. I mean, imagine everything we do is somehow or other connected with software, whether it's our cell phones or PCs, whatever.
right,
And you've
Mhm.
got to make sure it's valid. And it's even more important if you're going to be spending significant amount of money acquiring said software, or even the rights, as Dan said, to
Mhm.
software. If you're going to be paying a royalty, make sure you're paying for something unique. Now, as we started off by saying, Autumn, these intellectual properties, especially patents, are probably the most significant assets of many of these companies, and it has to be treated as such in due diligence. And with due diligence, we've all done hundreds of them. You get an army of CPAs in there, you get the attorneys in there, and everybody does think, do we put enough emphasis on valuing and examining the intellectual property itself more than just putting a check mark in the box?
right,
And I think that's where Dan and I can really roll up our sleeves and tell you the history, the risk associated with that intellectual property, as well as its potential value.
right. Absolutely. Yeah.
No, I can definitely say that you two make a dynamic duo and would only benefit, that company looking into this. So I just wanted to thank you guys again for talking about our key differentials and adding tangible value for understanding intellectual property today. Looking forward to hearing more from you both again soon.
Well, thank you so much for
Thank you,
having us.
Dan. Thank you. And it's a pleasure. And have a great new year.
Thank you. You too.